wants to usurp your powers. You are in the chair.
Chairman of the committee, if, in case you do not know.
Chairman, when we try to push, we get calls from your own side, we are in this together. I do not want to also get a certain impression that chairman, in an attempt to assert himself, would want to do things to undermine this very process. In all humility, since morning, I keep using the word, I beg you, I beg you. The nominee made reference to a constitutional provision to make a point. And I'm saying that not all of us are lawyers. Not everybody here is a lawyer. And I say, can you read the provisions and explain your point? Then you come and say, yeah, but I am here with him.
Honorable members, the question is coming from Honorable Bafo, and answers are being provided by Honorable Bafo. If Minority Leader wants to ask a supplementary question, at least he should allow the witness to complete the answer, but not to interject to say that read the constitutional provision without even the attention of the chair.
Chairman, with your leave, I pray that the nominee, as he references Article 125, he should read it in full to situate the argument rightly. Thank you so much.
Well, the nominee even quoted the 1251 verbatim, but you may go ahead and read it.
Thank you, Mr. Chairman. Article 1251 of the Constitution, that is clause 1 of the Constitution, says that justice emanates from the people and shall be administered in the name of the Republic by the judiciary, who shall be independent and subject only to this Constitution. I think I paraphrased it very accurately. And I was on the point that the internal logic of the laws, the PNDC laws establishing the public tribunals, was to ensure the participation of ordinary citizens in the administration of justice. And that aligns fully with the substantive content of Article 125, Clause 1 of the Constitution, because it says justice emanates from the people. In the context of Article 125, 1, the judiciary is the organ of state vested with the power to administer justice. And if the honorable nominee who asked the question, the honorable member who asked the question would care to look at Article 142 of the Constitution, which he referenced, all right? In that context, in the peculiar context of Article 142, the judiciary is defined to include the regional tribunals. What he left out is Article 142, I think, Clause 3, who says, and such other courts and tribunals as Parliament may by law establish. All right? So it creates, 142 creates the regional tribunals, which have coordinate criminal jurisdiction with the High Court, all right, in all respects. And then it says that Parliament may by law establish such, courts and tribunals, that is, inferior courts and tribunals, as it deems fit. Okay. Now, to the question why we want to bring back the public tribunals. We want to go back and align with the internal logic of Article 25, Clause 1, that there must be participation by ordinary people in the administration of justice. If you recall, all the tribunals, district tribunals, circuit tribunals, regional tribunals, had a chairperson or chairman and two who was, mandatorily required to be a lawyer, and two, other persons who were non-lawyers selected from the community. So aside the traditional jury system that allows, ordinary citizens to participate in the administration of justice in a limited fashion, the PNDC, in its wisdom, broadened public participation in the administration of justice through the tribunal system. Now, you referenced a report by Africa Watch. Of course, I am familiar with Africa Watch. If you go back to my CV, you realize that I was executive director of the Center for Public Interest Law, a human rights organization that I founded and ran for 10 good years, that conducted public interest litigation and represented persons whose human rights were being violated. So if you remember the famous case of Sodom and Gomorrah, I was a lawyer for the thousands of displaced persons in Sodom and Gomorrah using the Center for Public Interest Law. And so I'm very much aware of what Africa Watch stands for, right? But look carefully at the report, the date of the report. It will let you know that the empirical evidence for the statements that were being made, if at all, was gathered not from the era of the coming into force of the Constitution, but the era prior to the coming into force of the Constitution. Now, when it comes to our...
With your leave, the document you referred to, was it Africa Watch? Human Rights.
No, but he said Africa Watch.
No, let's there be clarity.
What? Yeah.
No. Mr. Bafo, please, let's repeat again the full document you referred to, because we don't want a situation whereby Africa Watch will say that they have not made any publication. What is the name?
Mr. Chair, this is not Africa Watch, the newspaper. It is Africa Watch, a human rights watch group. And he's aware. It's not a newspaper.
Wait. The document, is it an organization's report, or you are quoting from a publication?
It's an organization's report.
And what is the name of the organization?
The organization is Africa Watch, Human Rights Watch Group.
Okay, Leonard, then in reference to that, please quote it well. Respect.
Yeah, thank you, Mr. Chairman. I was very much aware of the fact that it's the human rights wing of the Africa Watch, but I was just referring to it in the manner that the honorable member stated. So if you look at the date, okay, my hunch is that the empirical evidence for, a report dated very close to the first quarter of 1992 would have been from the pre-constitutional, era, when the public tribunals were administering revolutionary justice in the context of PNDC Law 1. Now, if you look at PNDC Law 1, there was no human rights chapter. That was the Grundnorm. That was the constitution, the fundamental law of the land at the time. There was no human rights chapter. In resetting Ghana, we will reset it in accordance with the 1992 Constitution. And the 1992 Constitution is very clear, that the sovereign power of Ghana rests in the people of Ghana, in whose name and for whose welfare the powers of government should be exercised in accordance with this Constitution. Governmental powers includes the powers exercised by the judiciary of our land. That includes the public tribunals. I believe that it is not your view, honorable member, that the public tribunals would not or are not part of the judiciary. They are part of the chapter on the judiciary. And so they will be bound by Chapter 5, the human rights provisions, and the entire Constitution, guided by the directive principles of state policy in Chapter 6. And so the proposal in our manifesto is to re-establish the regional tribunals with criminal jurisdiction that is, coordinate jurisdiction with the High Court. And then we will have the circuit tribunals in all the districts, in all the, the regions, and then also the district tribunals that will also dispense justice in the various districts of our country. And I believe that if they are being regulated, and my proposal or my thinking going into this office is that we will enact a Public Tribunals Act that will be comprehensive, and that will, contain restrictions in terms of the conduct, of the affairs of the tribunals and the human rights violations that are, referenced in the Africa Watch Human Rights report will hopefully not occur. Not under my watch as the Attorney General of this Republic.
Thank you very much, Honorable Bafo. Before you proceed with your second question, Honorable Mahama Yariga has a follow-up.
Good. Honorable Attorney General nominee, do you intend to establish tribunals that will use caning and lashing of people as one of the punishments? Do you intend?
Mr. Chairman, I do not, and that will not be permitted by the Constitution of the Republic. In fact, that will be inhuman and degrading treatment of our citizens.
Minority Leader also has a follow-up, so you may wait for your second question.
Honorable nominee, have you become aware of the establishment of the ORA?
Honorable Minority Leader, a follow-up question must relate to the preliminary questions or the substantive question asked. But this is completely unrelated to the substantive question asked. So hold it. When it comes to your turn, you can pose these questions. Honorable
Chairman, with respect, please hold your horses. Let me make a point. We are dealing with matters of public tribunal. We are talking about issues that go complementary, okay? As far as possible from all that you've said. I am trying to appreciate the point you made in response to the question he asked, that would you set up a tribunal which would carry canes to be, chasing people here and there? You responded that no, because it will not be in accordance with law. Correct? In the same spirit, I am asking you that the ORA, that committee, which we've been told is to receive information from the public regarding supposed looting and all that. If you become aware of it, do you think that its establishment is in accordance with the Constitution?
Honorable Minority Leader, I believe the question asked relates substantially to Article 1261B. This oral that we are bringing in is not related to the establishment of the tribunal as stated in the NDC manifesto. So I reiterate the point that you can hold it. When it gets to your turn, you ask a substantive question, but this cannot be accepted as a follow-up question. Thank you very much, Honorable Leader. Honorable Bafo, proceed with your second question.
Honorable nominee.
Chairman.
So, Minority Leader,
Chairman,
I cannot ask a member
Chairman,
to proceed with a question,
Chairman.
and then you ask that he should hold on. This is unacceptable. It's completely unacceptable. So, Honorable Bafo,
Chairman.
proceed to
Chairman.
ask your second question.
Chairman, take it easy. Just take
Would you want to forfeit asking your second question?
Chairman, take it easy. 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 The nominee, please, he has raised a constitutional matter that if he tribunal with canes lashing people for the constitution, and he as AG won't do it. So I am asking, where or not, he's become aware of the aura, and if he has become aware of the aura, its mandate is within the ambit of the Constitution. So it is flowing from the very answer he gave on the constitutionality of the functions of a publicly established body, such as a tribunal. So, Chairman, I do not see why we should be locking on this matter. But however, if you insist, I will yield to you for us to make progress. If you insist, I will yield to you for us to make progress.
Honorable members, I insist that the question is unrelated. Question posed to the nominee relating to the establishment of the tribunal as contained in the manifesto of the National Democratic Congress. Honorable Bafo, may you proceed to ask your second question.
Honorable nominee, the question was, what is it that the high courts, regular high courts, are not doing that you need the tribunals to cure? That, honorable nominee, I didn't hear anything. But importantly, on the question of the promise that you are not going to set up a tribunal that will cane people, honorable nominee, are you aware that there is the criminal practice and procedure of this country is regulated by statute, and that statute does not include private citizens called ORA gathering evidence which will be handed over to the Attorney General to prosecute? Are you aware that there's nothing like that in the criminal, in the statutes of this country? Are you aware? Yes or no?
Honorable members, I know the nominee is capable of answering the question. But in our Criminal and Other Offences Act, as well as the Procedure Act, committees are not stated. But Honorable Nominee, may you proceed to answer the question?
Well, I'm sure the honorable member himself well knows that Act 30, the Criminal and Other Offences Procedure Act, does not create bodies, organizations, agencies, or entities that are mandated to operationalize criminal procedure. It merely lays out the procedure relating to criminal trials, whether summary trials, trial on indictment, and so on and so forth, and then relating to how you treat evidence in criminal matters. So it does not create bodies. So I would not, to your answer, there is nothing about oral in in Act 30. Now, the question whether oral is legal has been raised, by various people within the media, all right? Oral is the Operation Recover All Loot. If you look at the preamble to the Constitution, it is very, very clear about what are the fundamental values underpinning the Constitution. The value of accountability is one of the preambular commitments in our Constitution. It's a primary value. Oral is supposed to exact accountability from persons either politically exposed or persons holding public office who used or misused their office to loot public resources by way of property, money, and other intangible resources. So oral is constitutional. Oral is legal. In fact, the fact that it is a non-legal body doesn't mean that it is illegal. There's a distinction between non-legality and illegality.
Mr. Chair, please, if I may be allowed a follow-up.
Yes, you have my discretion. Before then, let me hear from Honorable Ayerga.
Mr. Chair.
He's coming in on a point of information.
Mr. Chairman, if you open the Constitution to Article 41, Article 41 deals with duties of a citizen. Please, everybody, listen to this. Article 41 deals with duties of a citizen. 41F says one of the duties of every citizen of this country is to protect and preserve public property and expose and combat misuse and waste of public funds and property. So if somebody forms a committee to elicit information about instances of looting of public property and waste and resources, is it not to provide an avenue for compliance with this constitutional provision? Is that not what it is?
No, we are.
And how different is this campaign from the campaign that took place recently? See something, say something. If you see looting, say it. If you see stealing, say it.
Mr. Chair, my
Honourable members, I will reiterate the fact that Honorable Ayerga, you are even not supposed to react. So observe the proceedings in silence. Honorable Ayerga, we are grateful for the point of information.
Okay,
you want to ask a follow-up question?
Before my last main question.
You are permitted to ask the follow-up question.
Mr. Chair, it is very interesting to note that notwithstanding Article 41F, the Criminal Offences and Procedure Act, Act 30, provided or has made provision for investigations, arrest, and prosecution of criminal offenses. And it still doesn't include oral or private individuals acting. But my follow-up is this. My follow-up is this. My follow-up is this.
What you've just said was a preliminary comment, but not a follow-up question.
Mr. Chair, I plead with you to indulge me in the interest of Ghana. Roxanne, you promised to protect.
Please go ahead with your last question.
Okay. So, in the year 2010, the NDC administration under Professor Mills commissioned the Constitution Review Commission that presented its report in the year 2012, for which a white paper was issued in June 2012. Hope you remember. Good. Now, you spoke extensively seeking to justify tribunals, the establishment of tribunals. At page 21 of the report of the Commission of Inquiry, of the white paper, on the report of the Constitution Review Commission, at page 21, the white paper stated as follows: maintenance of regional tribunal in court structure. Government accepts the recommendation that regional tribunal be abolished and matters handled by them incorporated into the regular court schedule. Government, however, holds the view that the chairman of the regional tribunal, if any, should be absorbed into the judiciary as high court judges. This is by an NDC government. The question is that when you had previously accepted the commission's report to abolish the Commission of Inquiry, to abolish tribunals, and now you say you are bringing it back, is it not double speaking? Especially when you have also failed to provide before us what the High Court is not doing that you want to correct with the tribunal. Is it not double speaking without any justification? Dated 2012, yes.
So what is the exact date on the report?
The report...
You are referring to the white paper
I'm referring to the white paper.
The report of the Constitutional Review Commission?
I'm referring to the government white paper stating its position
Very well.
on the report.
Very well. Honorable nominee, your response.
Yeah, thank you, Mr. Chairman. I'm very much aware of the position stated by the honorable member. I was very intimately involved in the work of the Fiajo Constitutional Review Commission, which was headed by my own good friend and former colleague, whose secretary was my own good friend and former colleague, the current dean of the University of Ghana Law School, Professor Raymond Atuguba. I am also keenly aware of the fact that the government white paper accepted to abolish the recommendation of the commission to abolish the regional tribunals. However, an American justice of the Supreme Court, a justice of the Supreme Court of the US, very famous, Oliver Wendell Holmes, he once said that the life of the law has not been logic, but experience. When experience has taught us that there are deficiencies in our justice system. In fact, when the honorable nominee was talking about the honorable member, I'm sorry, I have been here since 9:30, you have to forgive me. When the honorable member was talking about delays, he's a legal practitioner and he knows that the traditional court system is also plagued with a lot of delays. You also know that sometimes they disregard the fundamental human rights of citizens. During the tenure of your own government, Afoko, Gregory, when a court of law ordered that he should be granted bail, you still callously detained him, and he's in detention now. That's a violation of the right of Gregory Afoko to liberty. So these things occur whether you are dealing with the traditional court system or a tribunal system. Okay? The good thing is to have men and women of integrity who will administer the law or administer justice in accordance with law. And that is what we are seeking to do with the re-establishment of the public tribunals. I think that our experience has taught us that the participation of ordinary citizens in the justice system is a good thing. And that is why, having thought about it, we are re-establishing it. But of course, we are governed, as I said, by a constitution. There will be limitations to the powers of the tribunal as far as respect for the rights of persons appearing before them is concerned.
Thank you very much. I recognize Honorable Roxanne Nelson Kwame Eche Dafamapo for a supplementary question.
Chairman, thank you very much. Professor Aini, you are welcome.
Thank you, Mr. Chair.
You taught me, and you taught me well, and I'm very happy that you got this nomination. Now, you're also my chairman of the Subsidiary Legislation Committee, and I second chair you, and I know the quality that you put into your work. So, you also taught me legal system. So, let me clarify this. Are you actually saying that you are going to establish or create these tribunal courts, or you are going to implement the law? Because Article 142, Prof, is very clear in the establishment of tribunals. And it says, Chairman, with your leave, Article 142.1 says, there shall be established in each region of Ghana such regional tribunals as the Chief Justice may determine. Now, the Courts Act, 1993, variously amended in 202 and 203, actually imported Article 142 into the Courts Act and actually added more in terms of the creation of the regional tribunals. So when the impression is created that you are going to create these court systems, I got confused. So I want to find out from you, are you going to rather implement the law, asking that regional tribunals be established, shall be established, or is going to be your creature by policy? Chairman, thank you.
Mr. Chair, on a point of order, he said that the Courts Act.
You don't have the floor.
He says.
You do not have the floor. Even at point of order, I need to give you the floor. Honorable nominee, may you proceed to answer the question?
Well, I agree with my former student that I taught him well. He's drawn a distinction that I glossed over. The tribunals are actually established by the Constitution under Article 142. Now, the Courts Act was variously amended, and sorry, Mr. Chairman, but I don't have the the amendments here, but I do remember vaguely there was an attempt to delete provisions relating to the tribunals by the VCRAC committee. So if you take the compendium, the green compendium, I think that was where it was done. And the idea was to take them out, in terms of the statutory implementation. So what I would do, if Parliament gives me the nod, is to overhaul the law relating to the public tribunals by bringing a new bill that I will introduce rapidly, because the president has hit the road running, and we, his nominees and his appointees, are his, supplementary wheels. We have to help him, to run as fast